Welcome back to Key Talk Media. This your host, Key Talk. Check it out, man. Alright. I'm gonna give a shout out to the Notification Gang, Key Talk Gang. Give it all really the same thing for rocking with me every single video. If you listen to my voice right now, go ahead and like the video and hit the notification so you get a notification every single time I drop a video. Anyway, So Young Thug and Gunna had court today, and it seems like today a lot of the main topics was about figuring out how in the blue hell they're going to be able to hide the witnesses, and not only hide the witnesses because they did say that they got some more witnesses that potentially want to tell, but they're extremely terrified since, the one witness that did actually, the one that we all know that actually, his statements got out, Lil Woody, his statements got out to the whole public and the whole world, and pretty much, all those threats was made against him. So that's why I guess that other news had came out that people are pulling out and not wanting to really snitch anymore. So pretty much the prosecutors came to the judge and they're like, hey, listen, judge, man, the last buddy we had that was willing to snitch and testify, I'm talking about Lil Woody, his name got put out everywhere. He's got threats coming at him from all angles, and we do not want this to happen to the rest of the snitches that we've actually got and the people that maybe future rats and snitches that want to actually come out and tell on these guys from the YSL gang and also third parties. So what we're asking you, judge, is there's any way at all we can hide the doctrine of discovery, or not the doctrine of discovery, that's how they took over America. Is there any way we can hide the discovery, in order for the world not to be able to just see this right away? I know we can't hide it forever, but if we can just hide the discovery until maybe 30 days before trial, judge, please let us do that so we can hide all of our witnesses.
We would ask that the home addresses of our witnesses not be disclosed to anyone. We would ask, and should counsel have difficulty locating a witness, they can reach out to us, but we do not want a witness list with those addresses published. So that's our first request. Our second request is that the information on any proffers and statements of cooperating gang members be restricted until 30 days prior to trial. I will note for the record that at this time, all of our cooperating or gang associate statements, any statements made by someone who was once or is currently associated with this gang that we have, has been turned over. However, between now and then, should further individuals, defendants, or other associated gang members come forward, we would like the option to restrict that information on the proffers and statements until 30 days before trial. Our third request would be that this court order defense counsel, as officers of the court, not to disclose the current locations, dates of birth, or contact numbers of any witnesses with their defendants or defendants' family members. So while they may have that information so that they can contact them, we do not want the addresses disclosed, but
anyways, so not only are they trying to protect the future gang members that don't want to come out and snitch and tell, and giving their statements, they want to of course hide their statements, hide their proffer agreements. And if you know what a proffer agreement, that's pretty much how a gang member can say, hey, yeah man, I went on a hit with him and we both killed this person, but since they did a proffer, pretty much they wouldn't get charged with a hit, the person that they snitched on would. Anyways, they've also went to the lens of trying to protect, like the addresses, because, on the proffers or on the doctrine or whatever, on the discovery or whatever, you get to actually see the addresses and all sort of other information. So they're trying to hide as much information about the snitches as possible. And then they go on to say, even about the jurors and stuff, they want to hide all the information about that. So they're pretty much trying to make the case low key, which, like I say, that will be hard to do. They can't hold it forever. But they're just asking the judge if he can at least hide all that information until 30 days before trial.
Email address, phone number, that sort of thing, we would ask that be absolutely restricted from being disclosed to defendants in this case or their family members. We would also, our fourth request would be that this court order defense counsel to avoid sharing discovery materials with non-members of the discovery team. So if they're not of the defense team, I'm sorry, Your Honor. So if they are not a member of the defense team, we would ask that discovery not be allowed to be shared with anyone outside of the members of the legal team. We would then ask, our fifth request would be a request to restrict all parties, obviously that includes the state, all of us, from sharing discovery materials publicly. So I want to be specific about this. As we noted in one of our filings, a picture from the discovery, like someone took a photograph of a document out of discovery that named an individual that provided information to police. That document was shared publicly online. You can find it on Instagram, Reddit, YouTube. It's all over the internet. We want that not to happen again, and we're concerned that it happens, so we really want that restriction from anyone publicly sharing any discovery materials with news media, etc. And finally, we would ask for an order preventing the disclosure of any state's witnesses within the Georgia prison and jail system to anyone outside of the prosecution team without prior authorization from this court.
Anyways, so she then would go on to say that she doesn't even want Young Thug's team, someone to even be able to talk to Young Thug about anything that going on inside of the discovery. Don't want Buddy to know about any other people that's trying to rat on him or snitch on him like that at all, because she feel, or they feel as if, there's a possibility that Young Thug could potentially talk to somebody outside of the jail, and while he's talking to somebody outside of the jail, he could try to go and get their family hit up or something like that. So pretty much they're trying to take all the measures to, prevent that. Now, the defense for Young Thug doubled back and was like, hold up. Man, we've been preparing this case for so long, it ain't no way in blue hell they can take that right away from us for, being able to talk to our clients about the discovery. We got to talk to them about the discovery. And also, we got to know the discovery information as well, because when we go out to talk to these people that's in the discovery, we got to say, hey, you said this, is that, is that how you feel, da-da-da-da-da, and then that gives them the opportunity to say, hey, maybe I don't remember that, or maybe they do, and we show them the discovery that particular time to make sure, to refresh their mind or something like that. And he also said that he goes over the discovery with Young Thug every single day, daily, or just really, really often, and that would really pretty much backtrack them and stop them a lot from what they're actually trying to do, and it would actually hurt the defense of Young Thug if they're not able to have, able to discuss the discovery with Young Thug, or even talk to people inside of the discovery as well.
He believed that waiting until 30 days before trial for any, unfurnished or non-produced proffers of cooperating witnesses or gang members doesn't give us enough time for investigation.
No. So Young Thug's defense is pretty much saying that, those rules would hinder their investigation. So Young Thug's lawyer got on, he got up to talk to the judge, and he pretty much asked him, hey, judge, I don't mind if you do all that stuff, but can you just kind of make it to where Young Thug, Mr. Williams, he's able to at least still be able to see the discovery and stuff like that as well?
I would ask you to consider Mr. Williams and separately about, I didn't adopt the November 25, 2002 date. Mr. Williams is in a jail outside of Fulton County. There are 0 cell phones in that jail. Every one of his communications outside of his legal team are recorded. The state can tell whether he's talking about a discovery. He has done nothing to my knowledge to obstruct or intimidate at all. And to bound me with the other people who want to not share with their client until November 25th, they could do whatever they want. But I have the biggest issues here. I am in all of these overt acts. I have all of these witnesses to deal with. And if I can't share this information with Mr. Williams, I lose 2.5 months of work because I can't share with him information, then that is just not appropriate. If I ask you, if the other people, if Mr. Kitchens thinks that that's great for him, then I don't care what Mr. Kitchens wants to do. He doesn't have to share anything with his client. But I am not agreeing, and I'd ask you to rework, at least for Mr. Williams, this November 25th date. I understand the state's concern, but it should not be with Mr. Williams. I just want to share with Mr. Williams like we do everything. We go over all the discovery all the time.
Anyways. So now it's actually looking like, he's asking the judge if he can just, single out Young Thug and make it to where he can continue to go over the discovery with him like they do every day. But now the judge is about to actually come in and, so in a way right now it's kind of going against Young Thug that he's an actual celebrity with a lot of money, power, and resources, because in typical cases they wouldn't stop him from going over the discovery, especially with the people that's actually in the case and stuff like that. But in this particular case, they're actually, deciding to stop that simply because Young Thug is a celebrity. You're going to hear the judge saying a little bit of this is not the normal case. So now being a celebrity with a lot of resources and power is actually playing against Young Thug.
This is not the ordinary case, Mr. Steele, as you know. The state's asked me for a particularized reason to invoke the dictates of 1716-4 Delta. It's a pretty extreme remedy, and it's extreme because of the safety posture of this case. That is the only reason, and if it were not the case, then I would have no reason to do this. So I have to balance ordinarily your right to speak with your client freely, and I'm not in any way saying that that's not important, but I also have to balance the safety and interests of everyone.
Man, you know. So some people is looking at it like, hold up. So you telling me that, y'all are willing to, cut off Young Thug's lawyer as far as, making him lose 2 months of the investigation and stuff that he's had to do in order to defend Young Thug just to protect the snitches? Man, whenever it comes to this, like they say, the snitches are probably the most important parts of the case. So they're going to do anything in their power to make sure that no more violence and nothing is actually done to either the snitches or their families as well, or at least try their best to prevent it from happening. Maybe at the end they can't completely stop it, but at least try to stop it. So that's kind of what they're going through right now. Let me know something. Do y'all feel like, that they should allow Young Thug's lawyer to pretty much be able to talk to him about what's in the discovery, and do y'all feel like they should not be able to wait till 30 days before the trial starts, which isn't going to give Young Thug's lawyer enough time to prepare like they just said? It'll actually take away some of the preparation that they've actually done, simply because, they're not able to do the normal process of what you normally do in court, because like I said, Young Thug is a celebrity with lots of power and resources. Let me know something. Comment down below. Let me know what you think about this entire ordeal. I'm out.